10/21. This is the November 2020. I'm having a hard time with that. 2020 meeting of the Vermont Climate Council, and we just had a brief 15-minute break, and we are going to agenda along the theme of the transparency and working within the public space of governance, and what some of the expectations in the law and policy are, and how these are actually knowing about these rules and refreshing your memory about them if you were a former government official or employee. And there have been some updates, at least in both the public meetings and public records realms in the recent years. It's just important, I think, to have a refresher on these items. And again, I think those of us who've been in government at all know that the worst distraction to good work are being, accused of violating public records law or open meetings law and ethics guidance that may apply to you in your position. So we really want to protect the work of this commission and stay focused on the substance of the work. And so my goal here is to provide you again with an overview of these two key areas of law that we're going to be expected to live within. Make sure you know that they're out there, and also we will, provide whatever resources we need to members of the council to navigate any difficult areas they may find themselves in. Again, in order to be as transparent as we need to be with the public about this important work, and also to protect the work as we move forward without distraction. So with that, we are, I'm not sure, I think, who do we have first? Melissa, Charity Clark, or Michelle Anderson? I think that there was a change up. Is Charity, are you up next? There you are.
I'm here.
Okay, we have Charity Clark, who is an Assistant Attorney General and the Chief of Staff for Attorney General TJ Donovan, and she does public records work in the AG's office and advises many agencies and departments around the law and our obligations. This will be a pretty high-level overview of what the public records law is and why it matters. And I'm sure all of these conversations are going to bleed more questions and perhaps the need for some more fine-tuning presentations. But go ahead, Charity.
Thanks, Suzanne. Thanks for having me. So I'm going to just provide a basic overview, high level. If you have further questions or you have questions about protocols, you'll want to reach out to whatever council at ANR will be assigned to deal with public records for the Climate Council, and whatever attorney. In the meantime, I would suggest Matt Chapman would be a good resource, but hopefully this will be helpful to you. So I'm going to share my screen. Let's see. Can folks see that?
Yes.
Okay, thank you. So first, I'm just going to go over, here's what I'm going to talk about today. Basic background, we'll go over a couple of definitions, including public agency, public record. We'll talk about transitory documents. We'll touch on personal devices and accounts, the statutory time frame by which public agencies need to respond to public records requests. And then I'll just touch on a couple of exemptions to the Public Records Act. And if we have time, we'll have Q&A. So let's just begin by talking about the ancient tale of Watergate, which precipitated a lot of public records acts in our country, as well as a feeling of the importance of transparency in government. And certainly precipitated our law, which was passed in 1975. It's been amended a couple of times since then. Nonetheless, when you read it, you will find that it's not perfectly aligned to how we do business in offices today. For example, there's, clearly they're thinking about photocopiers when most of the public records requesters that we see in our office really just want a PDF. They don't want a photocopy. But the document's flexible, and case law has been interpreting the statutes as well. So I'll go over both statutes and case law today. But let's just talk about the statement of policy that begins the Public Records Act. It's kind of a preamble, and it's very lofty, so you can get your American flags out to wave. The goal is to provide for free and open examination of records, and it acknowledges that it's in the public interest to be able to review and criticize government decisions. It also says even if that's inconvenient or causes embarrassment. And this last one is really important. The Public Records Act is to be liberally construed to implement this policy, meaning it is to be liberally construed to provide records to requesters who are pursuing them. So this kind of begins the philosophy of the Public Records Act, and we go through the act with this in mind. It also acknowledges a statement of policy in the very beginning, the importance of privacy, and it mentions, you know, personal privacy and privacy in your economic pursuits. So it acknowledges right up front that there is this tension between those competing interests, and we will see later on that comes up again in the statute. So let's just talk about some definitions. The first I wanted to mention is what's a public agency. So I think the spoiler alert is I'm here talking to you because the Climate Council is a public agency, and you can see why looking at this definition. It's very broad. So any agency, board, department, commission, committee, branch, instrumentality, or authority of the state is a public agency. It was designed to capture a lot of bodies, including this one. So that's our definition of public agency. Once we cross the threshold of being a public agency, now a public records request is going to stick. So a public records request made on this body would mean that we would have to respond and collect whatever public records are requested. So the next definition we're going to talk about is what is a public record. So this is also pretty broad. It's been described by the courts as sweeping. So any written or recorded information, regardless of physical form or characteristics, which is procured or acquired in the course of public agency business. And the case law makes clear that it's not just procured or acquired, but also generated in the course of public agency business. So notice right away that the definition is contextual and not situational, meaning it doesn't matter where the document is located. It's just what is the document being used for? How did it come about? So let me just give you a hypothetical. Let's say you're dropping your kids off at school and you get a phone call from someone else on the Climate Council. We'll say it's Julie Moore. She's called you and she says, I have a great idea. Take this down. And you reach into the back and you pull out a sparkly unicorn notebook of your kids and you begin furiously writing down notes, telephone conference with Julie Moore, all these great ideas, sidebar, to-do list. You have some great ideas of your own. This is a meaty document. Is it a public record? Yes, it's been generated in the course of public agency business. It doesn't matter that it's in your kid's sparkly unicorn notebook in the parking lot at school. So that's important because I'm going to say this probably more than once, but you are going to want to find a way to keep track of all of the notes that you're taking, all the records that you are generating and acquiring in your work serving on the Climate Council, so that when someone makes a public records request, they're easy to find. So let's layer on another hypothetical. So let's say at the end of your conversation, Julie says, oh, by the way, tomorrow's Climate Council meeting has been moved from 10 to 11. And you reach into the console where you put your coffee and you find a sticky note and you write down Climate Council meeting changed from 10 to 11 tomorrow. And you stick it on your steering wheel so that you won't forget. Is that a public record? Well, yeah, it is a public record, but it is also a transitory record. So let's talk about transitory records. To do that, we need to talk about document retention policies. So every business agency, a best practice is to have a document retention policy or document destruction policy. And of course, the state of Vermont has policies. Many agencies and state government, including the Attorney General's office, follows the general records schedule. And the general records schedule, in a phrase, is you can throw away documents after 6 years. Don't tell the archivist that I made it sound so simple, because it's more complicated than that. And in fact, there's a lot of guidance provided, including, I was going to get back to it, transitory records. So this is not something that comes from the statute on the Public Records Act. It comes from the General Records Schedule, and it defines statutory records as those only needed for a limited period of time in order to complete a routine action or prepare or update a formal or ongoing record. Essentially, these are records that are designed to be temporary. So if you have that sticky note and you have managed to hang on to it, you haven't thrown it away, although you could. You've managed to hang on to it and you've stuck it on that other, note-taking that you've done. And someone says, I would like to request all of the sticky notes created by any member of the Climate Council. Do you have to turn that sticky note over, even though it's transitory? Yes, absolutely, because it's a public record. So something to keep in mind as you do your work, that you're welcome to throw away transitory records, but if you don't, you absolutely need to produce them if they're a public records request. Let's say you're in your car and because we're going to talk about personal devices, and you take your personal cell phone and you text your friend who also sits on the Climate Council. I'm going to use Julie again as an example and say, hey, Julie, can't wait for book club tonight. I'll bring the pizza. Oh, by the way, that Climate Council meeting today was great. I really liked Charity's presentation on public records, and I had some ideas XYZ. So you've communicated from your personal cell phone. Let's say you've mailed her or texted her personal cell phone. Is it a public record? Yes, it's a public record. What? No, that can't be true, right? No, it's absolutely true. If you are texting someone from your personal cell phone, but it meets the definition of a public record, then it's a public record, and you have to turn it over in a public records request. So it's not just me making this up. There is actually a Supreme Court case on this, Tenzing versus Attorney General. And whoops, I'm getting ahead of myself. And it's well reasoned. It's not going anywhere. It's the law of the land. So you should decide right now whether you are going to use your personal devices. And I don't just mean your phone. I mean your email, Facebook Messenger, any way that you're using to communicate with people. If it's done in the course of agency business, of Climate Council business, then it could be responsive to a public records request. So if you take one thing away from my presentation today, let it be that. Just be mindful of how you're using your personal devices and accounts to conduct Climate Council business. So why don't we just transition into, and I should say one more thing about this. I'm using personal because in the Supreme Court case, it was like a Gmail account or a personal account. It could be that some of you who sit on the Climate Council are here because as a part of your job working for a nonprofit or another stakeholder, you have been appointed to sit on the Climate Council. In that case, it could be that email that you are sending from your work account that's not your Vermont.gov account that relates to your Climate Council work, that's done as a part of your Climate Council work, could be responsive to a public record because it could be a public record itself. So keep in mind that you may need to decide if you're going to use your Vermont.gov account for all of that work, or if you're going to use your work account, and it's a little bit of a tricky overlap. So I leave it to whoever is going to be staffing this council from A&R to help you work that out. But it is something to think about because we do have this insightful case on the books. Let's talk about the statutory timeframe. As an attorney, I'm used to lots of statutory deadlines and timeframes, and it's like 20 days, 30 days, 60 days. Public Records Act, no, it's 3 days. You have 3 days to respond to a request for public records. It's pretty quick. And this is also why I'm emphasizing, please keep track of where your records are in relation to your work on the Climate Council. You're going to want to be sure you keep them all in one place so that when someone makes a public records request, you can find them really easily. So 3 days is very short. It's 3 business days. And for some reason, people have a hard time calculating. So I made a little chart to show you. If you get the request on a Tuesday, you have Wednesday, Thursday, Friday, it's due. That's your 3 days. And we have a policy where if we get a request after 4:30, which is when our office technically closes, or if we get a request on a holiday or a weekend, we consider that request as having been received the following business day. I should note also that there is a provision in the statute that imagines there might be, quote, unusual circumstances by which you wouldn't be able to respond in 3 days. So they understand that 3 days is pretty quick and you might need a little more time. It's not 20 days, it's not 30 days, but you could get up to 10 days. So that's the extension deadline under the statute. However, you can't just say, oh, I have an unusual circumstance, gonna need more time, thanks. There's actually 3 unusual circumstances enumerated in the statute, and you have to fit into one of those. And the 3 are, there's voluminous records, or the files are located off-site. There's some sort of complication with where they're located because they're off-site. Or the third one is you have to consult with another agency to comply with the request to sort out where the documents are or some other related problem. So those are the 3. And not only do you have those 3 restricting you, but you need to disclose to the requester which of the 3 you are invoking to get this extension, this 10-day extension. So something to keep in mind. It's a very quick turnaround, even if the circumstances are unusual. So I will just turn to the issue of the exemptions. So recall that the definition of a public record is very broad, and layered onto that are all of these exemptions. There's like 40 enumerated in the statute. And then after that, there's like several pages of a table that cross-references other statutes that make records exempt under the Public Records Act. So despite there being lots of them, we actually, in our office anyway, we only see a handful, but we see them again and again and again. So I've just flagged 2 that I think you might encounter in your adventures on the Climate Council. And the first one is the attorney-client privilege. So you will have a counsel, probably more than one, helping you with your work. And the attorney-client privilege basically says that communications between an attorney and their client are confidential. And it's not just in the records context, it's obviously in the law generally. But the Public Records Act acknowledges this and makes an exemption under the Act for records that are protected by the attorney-client privilege. But let me just say something about the attorney-client privilege. Just because you CC an attorney on an email does not enshroud it in the attorney-client privilege. It's a little more complicated than that. So we have a case on this too, which is helpful. It's not a Supreme Court case. It's a Washington County Superior Court case, but it put a little meat on the bone. So it's useful to keep in mind as you're considering whether something might be privileged under attorney-client. Here are the things to keep in mind. Here are like the guideposts. So 1, there has to be the existence of the attorney-client relationship. The communication is made for the purpose of facilitating the rendition of professional legal services. So this is language that's important. Client sought lawyers' skill and training. And let me give you an example of that. So say you email Matt Chapman and you say, hey, I wanted to ask you about, and it's not really legal, it's in some other, I hear you're an expert on Microsoft Teams, or I hear you're an expert on the science around climate change. I wanted to ask you something, but it's really not with him wearing his hat as an attorney. It's not privileged. It has to be in that arena. And then the last item that this case mentioned, which is useful, is the client reasonably would have expected the communication to be confidential. So that, in a nutshell, is attorney-client privilege. You could take a whole class on attorney-client privilege, but that's just the quick version for you. The other example that I wanted to give of the exemptions that might come up are personal documents. we have, I have a few examples for you. They're sort of the mundane. The first one is so-and-so can't come to the Climate Council meeting tomorrow. They're homesick. No one needs to know so-and-so's homesick. Redact. Another one that I see a lot is people's personal cell phones or personal email addresses. So I don't know about you guys who work in state government, but sometimes neighbors or friends will email my personal account with a work question, like they think they've been scammed, and I oversee the consumer assistance program. So I sort of forward that email to my Vermont.gov account. And if ever it was responsive to a public records request, that my Gmail account would be redacted. Another example is with a personal cell phone that I've seen more than once is, hey, I'm actually, hiking in the Grand Tetons and I don't get AT&T service. Can you call my personal cell phone, which is on Verizon? Here's the number, redact. So those are we see those a lot, actually. What we see a lot of in our office are records that are truly personal because they've been written by constituents or consumers. They might talk about, their financial situation or their health, or just like strong opinions about things that, are in some way reveal personal information. It occurs to me that some of you sitting on the Climate Council are kind of representing a constituency, and you might find yourself receiving mail like that. So I thought I would mention the famous case Trombley versus Bellows Falls, which provides, again, more information to help us understand what makes a document personal. So here are the bullets on that one. The privacy of an individual is involved. The information reveals intimate details of a person's life. And this next quote is famous: might subject the individual to embarrassment, harassment, disgrace, or loss of employment or friends. Sometimes we call this the loss of friends case because it's such a turn of phrase. And information is personal if it would normally not be shared with strangers. So this is just something to keep in mind as you might be receiving documents that have personal information contained within them. Something to be thinking about as you move ahead. All right, that's pretty much all I've got for my slides. I'm happy to answer any questions. I know that was very fast with high level stuff, but I'm here if anyone has any questions.
If I may just, Charity, if I may just add something for the group, not to fear, you are not on your own out there. If there's a public record request, the way it will work is that the council is the custodian of all of your records legally and technically. We will have on the website the name of our public records officer. So if an individual chooses to make a public records request for any of our materials, documents, those on that you have in your possession, but are actually council records, we will ask, the public records officer will ask you to gather your records and make them available. We will have them pulled together. We'll have a legal review of the records to determine whether any exemption exists. So you're not on your own, and you will not be receiving individual requests. We will treat those as a request to the council. But I think the real takeaway here is that the Supreme Court and the law really have expanded, not expanded, but clarified for us that it's the content of the record, not where the record resides, that makes it public. You have a duty to retain them, and when you leave the council, should you, for whatever reason, leave the council, we will be taking possession again of your email accounts that we have provided you. And that's my last comment is one of the key reasons for providing all of you with the State of Vermont partner email address is to help you maintain your communications in one place so that they're readily accessible when needed. If there's a public record, to take them into our possession with you when you leave the council as part of the public record of the council. If you do get personal emails on your personal accounts from folks who are talking about the business of the body, the simplest thing for you to do is to email that communication to your state account and hold it there in the event it becomes the subject of a public or a responsive to a public record request. And then you will not have to be searching your personal computer, which we will have an obligation to ask you to do if you keep it there. So with that, I will stop talking as well, and just felt it was important for folks to understand this. So questions, go ahead, Melissa, if you want to call on the people with their hands raised.
Certainly. Member Klein, please.
Yes, thank you. That was a great overview, Charity. I had possibly two questions, but the answer to the first might make the second not a question. Would, personal notes like jotting down shorthand about things that have been talked about in this meeting, is that something that would be considered a public record?
Yes, because you made it, go back to the definition. You made it in the course of doing your work on the Climate Council.
Okay, so, and then follow-up question, if I were to transcribe these into the, my document in Google, or not Google, Microsoft Teams, and, put it in, saved it alongside my account, would I need to then keep this piece of paper where I originally wrote it, or could I go destroy it?
I think that I would consider that to be transitory, because you were taking shorthand, and now you've used that the way that you intended to use it, which is to create this more fulsome, clearer document. But if you hung on to it and someone made a public records request that it was responsive to, you'd want to produce it.
Okay. Thank you. That's really helpful.
You're welcome.
Thank you. Member Cowart, please.
Thanks, Charity. That's for a great intro. I do have a thorny question about what might be called related work. I'm like many members of the council, we have other jobs. And in my other job, I engage with experts on climate policy all over the place. And so imagine I'm in a colloquy with a colleague or a government official in California. And I ask the question, what are the carbon savings associated with solar panels? And we go back and forth on that. So I'll pause and say, because that's related to my work on the Vermont Climate Council, is that email exchange a public record that I have to file here? Don't answer the question until I give you the second half. The second half of the question is, suppose I say to my colleague in California, hey, I'm really interested in that data because I'm on the Vermont Climate Council, and I think the council would be interested to know that information. Is that now a public record for this council? And if I ask that question at the end, does that mean that the entire preceding colloquy has now been roped into the work of the Vermont Climate Council? And is therefore your advice to me that I should never mention to anybody that any of the information I'm gathering out in the world has anything to do with the Climate Council?
So I have provided the basics, and I see I've done a good job because I've already gotten you thinking about the more advanced questions. I think that's probably going to be case by case, but I would definitely be having a conversation with whatever attorney is assigned from A&R, and probably Suzanne, on the approach that folks should be taking about that. And I see, lawyers are like, I'm just a tour guide to tell you what the statute and what the law says. So we know we have the statute, the definition that I read, and we know we've got that case I mentioned, which really has a lot of good legal reasoning that helps you understand why they took the approach that they took. And I think that I would look to that case to instruct on, okay, well, what about this? It's not personal, it's through your work that you're doing. But there's overlap. What do we do in that case? I think there should probably be a more fulsome conversation. I don't want to be the one to make that decision. I think it's probably a decision that others will have to make.
Thanks for that helpful answer.
You tempted me to give a more meaty answer, but I think I'll stop there.
Thank you. Member Clark, please.
Yeah, I mean, just to clarify, from what I'm understanding, basically, anything outside of your Vermont Gov email is a public record. Is that correct? Or is that like anything that's exchanged outside of that email or that body is basically public? I don't know if that makes sense, but I was just wondering.
It does. If you are making that communication or receiving that communication in the course of your work sitting on the Climate Council, then it would be a public record.
Great, thank you. Does that answer your question, Member Clark?
Yeah, sorry. Thank you.
And it looks like we have one more question hand raised from Member Johanna Miller, please.
Thank you, Charity. Question for you related to what Kelly was asking, so that we're not all scribbling notes that are then public record potentially. Is there a note taker in this conversation, and is there a shared Google Drive for all members and the public so that we are capturing the conversations that we are having, not just via Teams, but in writing, which I clearly know would be a public record?
So Johanna, we are using the Teams application, this is Suzanne, for the meetings themselves. Those meetings are being recorded, and these meetings will be posted after the fact. We are using the chat function to the extent folks choose to use it. And those chats, again, will be recorded while the meeting's being recorded. And that, to this point, is the extent of how we plan to use the Teams platform moving forward. We could have further conversations as we, start to figure out how to best capture the work. But anything on the Teams platform, is going to be public record. It's being, they're a public in this meeting now, and it will be posted. So we will have to, figure out how we want to use the Teams platform. It's got its attributes, but it also has its downsides. And so that's a deeper conversation we can have moving forward.
Okay, it looks like two more hands are raised. We have Member Dupi Jawar, please.
Yes, hi. I had a question about my role as state climatologist and the number of different organizations and peoples that I interact with, and how some of those data are actually going to sort of come into our work here on the council. I already have the sort of Freedom of Information Act piece that I'm particularly sensitive to from the UVM perspective, and I'm just trying to navigate how that would sort of play out from the council piece, because it becomes a little bit nebulous in terms of where things start and where they stop. So if you had any suggestions or how a deeper conversation, a deeper dive into some of that clarification could be offered, that would be great. Thanks.
Yeah, that it's tricky because there's going to be probably several members of the council who have overlap like that. And the Public Records Act is different than FOIA. There's a different approach. So I think that you'll probably want to have a conversation with, when the attorney is assigned from A&R, you'll probably want to have a conversation with that person separately, just to say, here's what I'm looking at, and get a better sense in the practical of how you're going to proceed.
Thank you.
Thank you. And Member Clark has her hand raised again.
Sorry, I have a lot of questions. So say like I kind of took this meeting by memory, and wrote down the notes, like my own personal notes from memory, like I didn't write them down by hand. And I put them in like a document in my like Vermont Gov email, and then like sent the like summary of the notes to like another council member who I know on this call and said, "Is this your takeaway?" Would that be like a public record, or is that like legal, or I don't know.
It's a public record. Yep, it's a public record. And when you have that question, you can go back to that definition of, was this created or procured in the course of my work on the Climate Council? And that it definitely was. You listened to the meeting and then you took notes that, that note taking would be responsive to a public records request for note taking or whatever. And, emailing someone else on the Climate Council, same. You're doing it in the course of your work as a member on the Climate Council.
Follow up on that, Charity, take it one step further. What if Sophia were to email her notes to a member of the public, a friend, a colleague, someone who's interested in the work?
Yep. So that would be generated, right, in the course of your work, I would say, especially if you're the young student member on the council, you might have other students in Vermont who are interested, who you're keeping updated. And I would say that would be a public record.
And I would add, there's no prohibition on doing that, Sophia, or any other members of the council. This is just to raise awareness that those documents, communications will be public record, and to just bear that in mind as you're drafting them, that they're respectful, that again, going back to Larry Nobbins, do you want this on the front, do you want this to be published in the newspaper? That so you just want to be respectful, civil, informational, and just understand, that it could be requested and shared with others. So.
Okay, thank you.
And another hand was just raised by Member Minter, please.
Hi, Sue.
Hi, I'm wondering, this is so helpful, thank you. If there are people in the organization I work for that are having an email correspondence and about policies that definitely relate to this work. And first I'm going to ask if they CC me on their correspondence, is that public record? And if they don't CC me on their correspondence, but then meet with me about the issues raised, are their correspondences public record?
I would say that if you were CC'd because you sit on the Climate Council, now we're into the public agency arena, and that's kind of what triggers that. If you are CC'd because of your other work, that would be different. But I also think it's probably very fact specific. So again, whoever is assigned to staff this council as an attorney is going to have a lot of these questions, I bet, come up as public records requests are made. And it's going to, you're going to have to find your way through it. And there's obviously helpful case law to guide, but I do think it's going to be pretty fact specific. And Sue, maybe you should also have a conversation with when that attorney is assigned. Maybe you should just, upfront reach out to that person and say, what should my strategy be here? What's this going to look like? Just so that from the get-go, you have an understanding of how you're going to handle things.
Thanks.
That's all the questions.
Charity, thank you very much for that overview. It's been very helpful, and again, it's just something everyone just needs to be aware is hanging out there and is part of the nature of being on a public commission like this. So we also have from the Attorney General's Office, Assistant Attorney General Michelle Anderson. She is the chief of the General Counsel and Administrative Law Division in the AG's office, a job I once held and really enjoyed. And you get to deal with all sorts of issues in that position, including public records and public meetings. So Michelle, if you're on, do you want to take it away?
I do. Good morning, everyone. I'm going to be giving you a pretty high-level review of the open meeting law this morning. very nuts and bolts and basic, although we'll be covering a lot of information. And I want to just admit up front that I stole almost all the material from the Secretary of State's really wonderful website, the Guide to Open Meetings. And I really recommend that to you as you do your work with the council. You can always check in with that. So I'm going to try to show you my slides too. Let's see. Is it up? Are they up there? All right. And I'll just dive right in. So to begin with, the open meeting law can be found at 1 VSA 310 through 314. And essentially, it requires all meetings of public bodies to be open to the public unless a specific exception applies. And in order to make the meeting open, the public body must provide advance public notice of the meeting, including the meeting agendas, discuss all business and take all actions in open meeting unless there is an exception, allow members of the public to attend and participate in the meeting, and take meeting minutes and make them available to the public. And I think that all sounds very easy, but the devil's really in the details here. So I'm going to also get into a few definitions. And the first is, what is a public body? As you can see from the definition, this council is a public body subject to the open meeting requirements, as are any committees or subcommittees that are formed. And that's a really important point because it means that all such subcommittees have to follow the same notice and public participation requirements for their meetings as are applicable to the council as a whole. Oops. Next slide. More complicated, however, is the definition of a meeting. A meeting is defined as a gathering of a quorum of the members of the public body for the purpose of discussing the business of the public body or for the purpose of taking action. This is simple enough when everyone is physically in a room together, like in the old days, but there are so many ways now to meet and communicate given technology that it can become very complicated. So first of all, as we see today, meetings can take place electronically, although in normal times, a physical location has to be designated for members of the public and at least one member of the body or one staff member or designee that will attend in person. Also, any member who participates in a meeting remotely must be able to hear and be heard throughout the meeting. Participation by speakerphone or Skype is appropriate, while participation by email is not appropriate. And due to the pandemic, the legislature made temporary amendments to the open meeting law to allow meetings to take place entirely remotely, like this one. But public participation and advance notice requirements are still there. So when meeting electronically, a public body has to use technology that permits attendance of the public, and whenever feasible, public access has to also be allowed by telephone, obviously because a lot of Vermonters don't have access to broadband or computers. And information regarding how the public may access the meetings electronically also has to be posted and included in the meeting agenda. And there's also a slight enlargement of time for posting the meetings, minutes taken at a meeting. But like I said, the greater ability to communicate through technology can also be dangerous because it can allow us to have meetings where we didn't even intend to have one. And this can happen, for example, in group emails. If a quorum of the board members are part of a group email that's discussing the business of the body, then you may well have a meeting on your hands, even though you didn't intend for it. And of course, if it wasn't properly warned, you've got a violation. Also, the law seems to allow for a gathering over time. So successive interrelated private conversations, usually an email about the board's business, can start out not including a quorum, but if those emails are shared and forwarded, eventually a quorum may be included. And again, you have a meeting on your hands. What about social media? same deal, and maybe even more dangerous, because if a quorum of your council is in the same social media group and the business of the council is discussed, this could also qualify as a meeting, even though none of the members even participate in the discussion. The collective editing of documents has also raised issues in some cases, because it can become a forum where the members end up discussing business outside of the public view. So the takeaway from this is you really have to think critically about all group communications to avoid inadvertently holding a meeting that doesn't comply with the open meeting law. At least the definition of a quorum is pretty straightforward. For this council, it's a simple majority of the total members, regardless of any vacancies or recusals. But back into a more difficult area is, what's the business of the council? So what are we discussing the business of the council? And as you can see, the definition is really broad. The public body's governmental functions, including any matter over which the body has supervision, control, jurisdiction, or advisory power. And you should think about this broadly just to be safe. But the law does carve out some things that don't require open meeting procedures. First, the body is not meeting to discuss business when carrying out purely administrative functions. And they list some examples, such as scheduling a meeting, organizing the agenda, clerical work, assignment of staff, routine day-to-day administrative matters, whatever that might be, that don't require action by the body, so long as no money is appropriated, encumbered, or spent. And I think this is an area that could be really difficult to determine when am I doing an administrative function and when am I really carrying out the business of the body. And that's you're gonna have to look at the facts of each case. But again, I would urge you to err on the side of openness and considering it business rather than administrative when in doubt. And the law also allows a body not to be considered meeting to carry out its business when attending other types of functions. So conventions, training programs, press conferences are specifically enumerated. A gathering of a quorum of a public body at a meeting of another public body is specifically accepted. And so are certain site inspections and bilateral collective bargaining agreements. The thing to keep in mind here is that all of these exceptions are for naught if, while members of the body are at these events, they discuss business anyway. So you really have to beware of the cocktail party conversation that strays into business. Okay, we don't have cocktail parties right now, but I hope we will again someday. But don't discuss business like that. All right, got behind on my slide. So the next area I want to talk about is notice. What sort of notice is required when you hold a public meeting? So for their regular recurring meetings, the public body usually adopts a resolution setting the time, place, and manner of the meetings. And I'm not sure how you're going to do that. But this information has to be made available to the public upon request. And then there are also special meetings, which are meetings outside the regular meeting schedule. And public notice for these meetings has to be at least 24 hours in advance. And there are some specific requirements. You have to provide the meeting's time, place, and purpose to a newspaper or radio station serving the area, as well as to any person who's requested in writing to be notified of the special meeting. And then all public bodies must give oral or written notice to each member unless the member has waived the notice. And then there are emergency meetings, which obviously don't need to be noticed at all, except as soon as possible. And what I would caution you about here is make sure before you invoke this exception that the meeting is really an emergency, where you had no ability to provide even the 24-hour notice that would be required for a special meeting. The definition is an emergency meeting may only be held when necessary to respond to unforeseen occurrences or conditions requiring immediate attention. So a lack of attention to the business of the body at the last minute, you decide, oh, let's have a meeting. That's not going to cut it for an emergency. It has to be something unforeseen has to arise. And also, a part of notice is the provision of an agenda for public meetings, which must be posted to the website if one exists 48 hours in advance for a regular meeting, and then 24 hours in advance for the special. So for the special, it would be the same time as you post your regular notice. And then there's no requirement, obviously, for an emergency meeting to have an agenda. And then when we're looking at what has to be included in an agenda, the law doesn't require very much specifically, except to require that the agenda must designate a physical location. Although, as discussion, although this has changed during the pandemic, so now that we do allow electronic participation. But the Secretary of State's office, in keeping with the law's intent, recommends that an agenda should allow interested members of the public to be reasonably informed about what specific topics are going to be discussed, what actions are going to be taken at the meeting. So even though there's not a strict requirement for more information, it's a best practice to include it. And if you want to change your agenda, you can add or delete items as the first act of business. And this is funny, Melissa actually asked me this question yesterday about this very meeting. But you don't want to change anything too substantive at that point if you can avoid it, because you really haven't informed the public then of what the meeting's going to be about. So if you're introducing a whole new topic as the first order of business of a meeting, the Secretary of State's office would recommend that you add that to the next meeting rather than try to take up the business at the meeting that you're currently having. And then there's a requirement to take meeting minutes. And these, we do have more guidance here. The minutes are to give a true indication of the business of the meeting and covering all topics that arise. And at a minimum, they have to include the names of all the members of the public body who are present, the names of all active participants, all motions, proposals, resolutions, and their dispositions, the results of votes, and with the record of the individual votes if a roll call is taken. And you have to make the meeting minutes available within 5 days of the meeting, post them to your website if you have one, and keep them for up to 1 year. But despite all this discussion about openness, there are instances where a public body can meet privately. And one of them is when you meet to deliberate in a quasi-judicial proceeding. But the most common reason for meeting in private is executive session. And that's to discuss certain topics that require a degree of privacy. To enter into executive session, a motion has to be made in open session that indicates the reason for doing so. And for a state body, a 2/3 affirmative vote is required to carry that motion. And the only permissible reasons for entering into executive session are set forth at 1 VSA 313, and there are 2 separate categories. In the first category are topics that can only be discussed in executive session after a finding that premature general public knowledge would clearly place the public body or a person involved at a substantial disadvantage. So once you've made that finding, you can discuss in executive session contracts, labor relations agreements, arbitration or mediation, some grievances, matters of civil litigation, and confidential attorney-client communications. And then there are topics that can be discussed in executive session without that finding. And these are listed below, including negotiating or securing a real estate purchase option, the appointment, employment, or evaluation of a public officer or employee, a disciplinary dismissal action against a public officer or employee, a clear and imminent peril to public safety, when you're discussing exempt public records, and when security or emergency response measures, if disclosed, could jeopardize public safety. And a couple other fun facts about executive session. One is you can invite others to executive sessions. For example, legal counsel, clerical staff, people who are involved in the matter being discussed, or people you need information from can be included in your executive session. But one important thing to remember is that even though you can discuss certain matters in executive session, you have to take any formal action related to that in open session, except for the securing of the real estate purchase option. So if you as a public body inadvertently violate the law by holding a meeting that was not properly noticed, or wrongfully excluding a member of the public, or by holding an executive session improperly, you have the opportunity to acknowledge the error and to cure it within 14 days by either ratifying the action in open meeting or declaring void any action that was taken. And the public body must adopt specific measures to actually prevent future violations. And hopefully, none of you will ever need to know this, but there are criminal penalties for those who intentionally violate the open meeting law. It's a misdemeanor carrying a fine of up to $500. And members of the public or the Attorney General can bring an enforcement action asking courts to grant injunctive relief, declaratory judgments, or award attorney's fees in cases where the open meeting law isn't followed. So I know that is a very swift run through of the Vermont's open meeting law, but I'm happy to take any questions.
So are there any questions from members of the council? If so, raise your hand or speak. So if you don't have that function.
A lot of experienced practitioners out there.
Thank you, Michelle. This has been very helpful. A good reminder that in today's electronic world, a meeting is more than just a group of people in a meeting room. And it does kind of tee up nicely our next agenda item, if there are no questions, which is the December meeting. And you posed the question, I'm not sure what this council is going to do by way of regular meetings. And it is something that is going to have to be one of our first orders of business for December. And I was thinking that Melissa could, without creating a meeting, as Michelle has pointed out, send out another doodle poll or survey of a few things. What days, if we are going to have a regular meeting, what do you think? Should it be monthly? Should it be twice a month? Should it be a 4-hour meeting? Should it be an 8-hour meeting? But we've kind of have to work with this large group to find I think some regular time to meet. And I guess my question to you, Michelle, if you're still here, is, if we find we're such a large group and every month is going to be on a different day of the week or not on the third Tuesday of every month, those would be special meetings that would be warned and would just require some additional notice. I think we may have lost Michelle. I shouldn't have let her go, but we'll work that out. But I'd love to hear any feedback or initial reactions to that, because it's going to be important that we find a rhythm and a stride, I think. I don't see anyone clamoring to raise their hands and offer up any feedback or input. So hearing none, I think what you can expect, at least from Melissa and Angela or Angela, is something in the near term to try to set up a December meeting. We were fortunate that Secretary Moore pulled together at least a proposed approach over the next 2 meetings to lay the substantive foundational work for the entire panel or council to be present at before we break into council subcommittees and determine how we want to populate those subcommittees. So we will work to get some surveys and some input from you that way over the next week or two. Sophia, did you have your hand raised?
Oh no, I was just gonna ask about the subcommittees, but you kind of answered my question. So
I think the method to our madness, and again, we're always open to feedback and suggestions either here or in the survey, which will be a public record. You know, on the agenda, building the agenda, if you have some specific requests or questions you would want on the next agenda. We have another question. Is there another hand raised, Melissa?
We do. It looks like it's from, sorry, I'm trying to look at my two screens here. Member Dimitrek, please.
Hi, thanks. I just had a question about the open meeting law in regards to the chat function, and I think we lost our person, but maybe we can pass this along. Since some people join by phone and some people join by video, curious if the chat function meets the requirement of being able to hear and be heard. And if not, we should be really judicious about utilizing the chat function for any side conversations.
That's a good point and a good question. And again, the meetings are recorded and that chat function is recorded as well. And so in terms of posting the video of this meeting, it will also include the chats, but we do have to be mindful that that is an opportunity for members of the public who have the access to the chat to participate. And sometimes in past meetings, you know, sometimes that's where a member of the public decides to comment rather than comment, you know, on video. So thank you for that.
Speaking of the chat function, Member Minter said that she likes Friday mornings and believe monthly makes sense. And we also have a hand raised from Member Johanna Miller.
Thank you. I was raising my hand for a couple different reasons. I like Sue's suggestion. I mean, I think a doodle to see what works well for everyone makes sense. Friday mornings seem great. I agree, monthly probably makes sense. So, but I would love to see what works for all or most, knowing it's challenging with very busy people. A couple of other thoughts, and I also just want to say thank you to Secretary Moore and to you, Secretary Young, and to all the state agency folks who have put together that overview and then are going to lead into the next couple of meetings with sort of setting that contextual framework. It looks like there's a lot there. Two thoughts or sort of maybe recommendations I would make to further set the context would be, I would really like, I think the work that Energy Action Network has done is really important and a good foundation to inform this conversation. So if possible, a presentation and not just a link to their really great and I think easy to access publication, but to hear from Jared, especially as that work gets, has been updated a little bit. And I think there's been a layer of consideration of equity and the economics, which I think was really strongly stressed by many folks today, and I think obviously is really key. So I'd like to make that recommendation as food for thought for, and then secondly, another thought, knowing that, you know, Vermont is embarking on this now, but other states have also embarked on this effort, including neighbors in Maine and Massachusetts. It may be helpful to potentially hear from some of the leaders of those efforts, like how they're standing up their work, and especially the subcommittees. I've had a couple, I work, as I noted earlier, on a lot of regional partnerships, but I think there may be lessons learned and may be helpful, so we don't have to recreate the wheel, and make sure that we are as open and inclusive and you know, learning from how they're doing it, so that might inform our really important work here. So two specific ideas I thought I just would lay on the table. Thanks.
Those are great ideas, and I have looked at the Maine Climate Council website, which it basically operated, I think, in the same time frame, only a year earlier than this one. And I noticed that they have some creative ways of, posting webinars that members, on specific topics that members can attend at their own pace if they, if we can't fit it all into a 4-hour meeting, which is going to be a challenge. So I think that's a great idea, and I would commend, at least that's the website I haven't really taken a deep dive into, but it seems like it could be very helpful. And Secretary Moore and I did discuss maybe we could invite someone from Maine to speak with us, so we wouldn't be reinventing the wheel and learn from them. So those are great ideas. Thank you.
We have a few comments in the chat. Member Farrell agrees with Sue's suggestion regarding the timing of Friday mornings monthly. Member Liz Miller said that the legislative schedule may need to be taken into consideration and account for state members. In general, they would usually weigh in favor of Monday, but she knows that this year will be different. She thinks helping set this up. And Member Oates agrees that bringing Jared in as the energy data analysis rep to give us an overview of the state of the state regarding energy would be really helpful. And there's also a hand raised by Member Dupuy-Giroux, please.
Yes, thank you. So I wanted to offer maybe the 3 to 4 hour time frame as a block, as opposed to the 8 hour, which might be a little bit challenging for everybody to be able to attend, especially for the entire day. And one community that might like to participate and offer additional assistance might be folks in academia. I know there are a lot of folks at UVM, Middlebury, Castleton, Johnson, who would love to participate. And so keeping in mind the academic schedule would also be a piece that would help us with our participation representation. And since I have the floor and since I have to be presenting a lot of stuff at the December meeting, I'll try and reach out offline to make sure that, like once finals are done, all that good stuff, we can make sure we find a time that, I could actually be there. So thank you.
And we have another hand raised by Member Campany, please.
Hi, I put in chat just 2 references. One was about the regional and town municipal energy plans that have been developed under Act 174. There was a lot of work that was put into those, and I would just encourage people to look at those, follow that link to the VAPDA website, and there are links there to each of the regional planning commissions. We also have a map there of the towns that have adopted and have approved enhanced energy planning elements. The legislature did a lot of work on that. The regional planning commissions did a lot of work on that, and the municipalities did a lot, all of which had to meet very specific energy criteria. And we just encourage folks to look at that. And also, just so folk are on the resilient side of the equation, I posted a link to VEM that describes local all hazard mitigation plans. And just so folk are aware that those things exist. And as examples, I provided a link to the Wyndham Regional Commission site, to our towns page, and a link to a specific the town of Guilford's all hazard mitigation plan. You'll see that a lot of work goes into those, and they're specifically designed to be actionable. But I just want people, because for folk who don't live in this world of regional and municipal planning, I would just encourage people to be at least aware of some of the work that has already been done.
Great. There's so much work that's been done, to your point, Chris, and so many spaces in this conversation that we do need to start gathering up the materials, both that are referenced in the statute as well as the other pieces of helpful work. So I appreciate that, and we'll maybe in the poll we could just ask folks to include links to what they think would be helpful resources, and we can start a resource page.
Member Duval has his hand raised, please.
Thank you, Melissa. I just want to agree with Dr. Dupini-Giroux around the 4-hour meeting length. But having said that, and I know that long-term, a lot of our work will happen in subcommittee, but given the importance of our work, the December 2021 deadline and the amount of work that has to happen between now and then, I think we should be open to meeting every other week, at least to start, until we get that subcommittee structure set up and we know and we have a sense of the timelines and how we'll collectively meet our responsibilities. Just wouldn't want to have too long between meetings and then feel a crunch as we're nearing deadlines for our work together. I would also say, you know, I am of course happy to provide a comprehensive overview in a short way that connects emissions, energy, the economy, and equity, not just what's happening here in Vermont, but also in comparison to the region and nationally. But my request in terms of the agenda for December, maybe not the next meeting. I know there's a lot of things that we want to include, but I think it will be very important early on in one of these next meetings to, I especially would appreciate, and I think the council would benefit from an overview from Member Cowart, roughly talking about ways that different states, different provinces, different countries have approached the task of greenhouse gas emissions reduction. He has a wealth of knowledge, given his work here in the United States and in Europe, to provide an overview of some of those different approaches. I think will be really helpful conceptually for us all to get our heads around, not to get to the point of making recommendations, but to at least share some of the different ways that different governments and jurisdictions have approached this similar work.
Okay, thank you. And I do think, you know, your point about the time and 4-hour blocks and the amount of work to be done, but the amount of information we would want to gather before we broke into subcommittees is very important. So I would urge everybody to think about whether we can do some of this work through, you know, webinars that folks can attend, you know, at their leisure. And so there are some creative ways I think we can work around our time constraints. So I welcome everybody's thoughts on that as we move forward.
Those on the phone, there's a few more comments in the chat. Bob Farnham, guest, has consolidated a lot of work with the Vermont Legislative Climate Solutions Caucus work from last year and offers it as a resource along with a link. Member Clark agrees with Jared and Sue on timing. She also agrees that the energy data analysis would be very helpful to get everyone on the same page. A guest, Annette Smith, says, when I served on Vermont's committee to ensure clean air in 2001, it met in person in Montpelier every other week. It was a high-level committee and everyone made the time. I think every other week makes sense for this council given the workload that you've been tasked with. And that concludes all the chats and the hands raised at this point.
Thank you, Melissa. Well, that leads us into the public comment portion of the agenda. I would welcome any member of the public who's in attendance who wishes to comment to raise their hand, and then we can sort of allot the time we have remaining in the agenda to those individuals, depending on how many there are who would like to comment. So we'll give you folks a moment to raise your hands, and once we see how many we have, we can get started. And Melissa, I'm not sure if anybody signed up before the meeting that you would want to call the roll of.
They did not, and so far we only have one hand raised.
Okay.
All right.
Welcome, Jess.
All right, Robert, why don't you go ahead, please?
Sure. My name is Robert Lamert, and I am a specialist in negative emissions. And that is a field which is covered under the bill as sort of an alternate methodology. To reach the goals, which are stated for 2025, is going to require some very significant behavior changes on the part of many of Vermont's citizens. And some of them are somewhat reluctant to change their behavior on short notice. And 2025 is, I think, short notice. And I just wanted to indicate that in many of the meetings that I've attended, there's been a breakdown in the understanding of what is being accomplished in reduction of greenhouse gas emissions, and somewhat of a confusion between carbon dioxide and carbon dioxide equivalents. And there are other greenhouse gases which are opportunities for significant reductions. My particular field involves work done both on a national basis and an international basis. I have a lot of connections in New York State, which is doing some very significant work in negative emissions between NYSERDA, Cornell, and Rochester Institute of Technology, and the SUNY system. Also doing work with a number of states on the West Coast. California had a Global Warming Solutions Act in 2006. And they are very far advanced and offer many webinars to explain their progress along the way, which could prove very useful. My work in Vermont at this point involves a number of projects involving clean water. I am working on methods to reduce the amount of phosphorus and nitrogen in our water. And those are not, strictly speaking, global warming issues. I am also working with a number of advanced wood heating systems that may be installed in Vermont, as well as some of the major pellet suppliers. I am also working on a sort of a Model T, a very basic type of advanced wood heating unit that would be useful in making steam, hot water, and electricity in unheated spaces such as highway garages and things of that nature. I also have a lot of connections internationally with respect to carbon removal certificates, which are sort of a much more sophisticated method of quantifying the financial value of carbon. And there's a very active trading market in the carbon removal certificate market at this point. At this point, it's over $30 a ton. And there's very active trading. There's sort of unlimited demand for this type of vehicle for voluntary carbon removal by private companies. And that is a vehicle which could prove to be very useful to the state of Vermont as part of financing for a payment for ecosystem services and for meeting its climate emissions reductions targets. And I just wanted to introduce myself.
Well, thank you for doing that, and thank you for that information, Mr. Lehmeyer. So that appears to conclude our public comment, and that concludes the agenda. So if, as I said, Melissa and Angela will work to set up a meeting in December and see if we can land on a regular meeting day and number of hours, and if folks could give some thought to other ways to creatively meet with the time constraints and the space constraints that we're working under. We're always open to those suggestions, and maybe we'll leave that as something that you could respond in the doodle poll to if you have some good ideas. So if there's no other comment, I think the meeting is done, and if there's no objection, I will declare the meeting adjourned. So it's easier than taking a roll call vote if anybody feels they don't want to adjourn. And Sophia.
Hi, thank you. Sorry. I was just thinking, this is kind of like irrelevant, but something the Sierra Club does is like a community happy hour. And I just wanted to give that as like kind of something to talk about, maybe just as us as a council to also connect on a human base, you know? So that's just an idea. I don't know if people have the time because we're all super busy, especially all of you guys, all your businesses, and awesome work. But I just thought that'd be cool. Yeah, so something to look into.
Thank you. Thank you. Anybody else? Okay, well, we will get out a date and a time and a notice for the next meeting once we land on one that works for hopefully all, like we did today. Thank you all for coming, and the 100% attendance rate is something we can aspire to every month. So I appreciate it. Have a nice weekend. Stay safe out there and stay warm. I hear we might get some snow. All right. So in order to have meetings, yep, you hit the leave button and you will be disconnected from the meeting. And Melissa, you may stop recording.
Thanks for a great meeting.
Bye, thank you.
Bye.